Hi, my name is Attorney Walter Rudolph Hnot III. I'm with Disability Resolution PA in Orlando, Orange County, a Social Security disability law firm. The ALJ, we're going to be doing the next question on this. The ALJ denied you because you could hypothetically work, and here's why. So the question is, why did the ALJ deny you? So a lot of you have gotten unfavorables, right? It's the little piece of paper. It says unfavorable at the top of it, and then you scroll to the very bottom of the whole little thing of papers, and you see this, well, we think, a couple of paragraphs up from the very bottom, that the claimant could do this job, and this job. And it's almost always in groupings of 3 unless your attorney was able to kill 1 or 2 of the jobs. So that's kind of how that all works. Now, with that said, and why this is very important, is that, bottom line is that the judge will ask the VE, the vocational expert, hypothetical questions as to jobs you could potentially do. You'll know you're going in the right direction. You'll know you're going in the right direction if, how do I phrase this so you guys will really grasp? You'll know if you're going in the right direction if the judge is putting a bunch of limiting factors onto the hypotheticals. Not necessarily the first hypo. The first hypo is like there's not much wrong with this guy. Are there jobs out there? That's not the one you're listening for. But like hypo 2, hypo 3, hypo 4 in there, when you start to hear all these limiting factors, okay, well, what if he could only do this occasionally? What if he could only do this, never at all would be one, or it could be, like frequently, constantly, how they live. What if he could only lift this many pounds? What if he could only, do this function for so many hours a day? You're listening for functional limitations. So you're listening for that walking. So let me actually read some to you because I was starting to blank and then go, okay, let's go to this. Climbing ramps, stairs, climbing ladders, ropes, scaffolds, balancing, stooping, kneeling, crouching, crawling, reaching, waist to chest, reaching, above shoulder, handling, fingering, feeling, talking, hearing, tasting, smelling, near acuity, far acuity, depth perception. You've got all these things. How much can the person lift or carry? Occasionally, frequently. Then some of the mental ones. Limited work that requires interaction with the public, co-workers, supervisors, others, limited to work that requires, supervision, limited to work that requires changes in the work setting. So there's all these little things, right, which essentially equate to limiting factors that the judge could give that say, hey, this person, realistically, cannot do functional tasks, in a work environment because they have these limitations. And what you really want to be listening for are the, can't do it, the no's, can't do that particular function, the occasionally or the frequently. Because if they constantly do it, it's not going to help you in any way. But frequently, statute-wise, it's not going to help you too much. But if you hear it, that's not a bad sign. And then occasionally, that's the one you want to listen for. That's the one you want. Okay, what if this person could only occasionally do that function? Because that just means that you can only do that thing 1/3 of the time of workday. So if a standard 8-hour workday is your 8 hours, then 1/3 of that time you can only do that function. And there's a lot of things that you need to do, walking, standing, pushing, pulling, whatevering, as part of work, that if you could only do it 1/3 of the workday, you wouldn't be able to do that job. You would be fired. And remember, what they're asking here is, what job can you do in the national economy? So they're expecting you to hypothetically move to Alaska, Maine, Kentucky, California, Texas, Florida, wherever. So wherever you are, they expect you to actually move to be able to handle these functional tasks, which is insanity, if they expect you with no money to move to a state such as Alaska. I mean, it's expensive to get to Alaska for anybody, right? You're not going to drive your car through Canada. I mean, you might if you're a trucker, or just somebody who wants to go for a drive in the summer. Otherwise you're talking like logging roads, that are completely filled with snow. But bottom line, that's how the system works, hence one of the reasons why it's actually broken. But let's go back to the question. The ALJ denied you because you could hypothetically work. Here's why. All right, there's another thing too. A lot of you guys put in your initial filing forms a lot of really stupid things or bad things or things that worry me immensely, and those are things about how you have egotistical abilities to complete things. So like taking care of others, assisting people with their kids, assisting people with all of their different pets, and you ride your bike 2 miles every day, and you go to rock concerts and blah blah blah. And I get it, some of it might be true, but then some of it might just be ego. So you guys got to be careful, because the judge uses that. They'll go back and look at your 3373 and they'll be like, claimant enjoys music. Farther down the form, claimant goes to rock concerts. And now it may be true that you used to go to rock concerts 20 years ago, but that you're no longer able to go to rock concerts now. And because of that, the big problem is now they've got a statement. It's a federal statement on a federal form submitted to a federal agency, the Social Security Administration, and now they're able to use that in a binding way against you to make sure you get no benefits and unfavorable. So if you're able to go to rock concerts and you're able to do basic sedentary and or light work, why couldn't you do a ticket taker job, or some job where you're sitting at the rock concert, etc.? Right? There's a question. So that's kind of how that works. So let's go back to the question. The ALJ denied you because you could hypothetically work. Here's why. So we went over a couple of things. The next thing I want to go through is hobbies. We talked a little bit about the rock concert, but when it comes to hobbies, if you do not cut it off that you can no longer do those functional tasks, whether it's soccer, foosball, horseback riding, whatever, then what's going to happen is they'll use that against you to find that you can do a job relevant to that. Like if you're cleaning a house and consistently cleaning and nobody else is helping you, then guess what? You could do a motel job. So seeking discipline, let's see what the other one is. So hypothetically work. A lot of you guys also have this thing where you tell yourself on an emotional level that you can't work, but you might actually be able to work to some degree. I've noticed with a lot of stay-at-home spouses, I was trying to be gender neutral there, but realistically what I was saying in my mind was stay-at-home wives, that basically they say I can't work. Well, that is, I gotta move because I got a little doogie here who's limiting my feet. That is a form of working, being able to function and complete things and do stuff and whatever. That's all part of that gig. All right, so if you're cooking and cleaning and doing laundry and you're doing hygiene related tasks and you're shopping and all that stuff and you're taking care of 4 children, that is a job in itself. Okay, that's why they have caretaker jobs. Caretaker for the youth, caretaker for middle age, young age, elderly, whatever. Okay, so could you hypothetically work? You'd say no. Now here's where you attack that stuff. When you say you can do something, make sure you curve it to explain that you couldn't do it over an 8-hour workday, right? Because almost all of this law is premised on the idea of, honestly, the Masonic code, which is 8 hours for work, 8 hours for sleep, and 8 hours for just, having fun doing whatever you want to do. So what that means is it's an 8-hour workday, going way back into time as the official 8-hour workday, which equates to basically, your standard of, can you go ahead, stand and walk for 6 out of 8 hours? Can you only sit for 6 out of 8 hours and then stand and walk for 2 hours? And you have to understand, you should really check it out. Code of Federal Regulations, this is where you begin with it. It's 404.1567. That's the beginning of you understanding what are the different levels of work, whether it's sedentary, light, medium, heavy, or very heavy. And if you understand those, you can then take the next step to do analysis onto what SVPs are. Then you can take the analysis onto what vocational experts are trying to put you into in the DOT when they look at jobs. DOT stands for Dictionary of Occupational Titles. So the bottom line here with this whole thing is that you'll start to kind of grasp more of why they're saying that you could do these jobs. Now, why is this important? You're not going to write your appeals counsel brief. You're going to have an attorney write it for you. So that's really why this is important. But, the reason I tell all my claimants, okay, and it's a really simple reason, the reason I tell all my claimants, look, dude, and a lot of my claimants are like, I don't have to read this, I don't have to learn this, I just want you to do everything, oh my goodness, I don't want to have to think. And I get it, and that's cool and all, but the more you know, the more of what's coming out of your mouth is going to be in line with the statute. That means that when I'm not standing next to you going, shh, or he actually meant this, or what she was really trying to say is this. If I'm not standing next to you, okay, then who's there to control what you are saying? And if you're sitting there going, well, I can control what I'm saying, that's great. All I ask is that you learn how to do testimony preparation for what you're going to say. And it's usually the most egotistical person out of all, the room. That's I'm capable. That's the one I worry about the most, because they almost always get themselves into trouble because they'll say that they can do things that which they truly could not do. And I'll give you an example. Something that I usually bring up at the hearing is, all right, now walk me through this. If you could do the following job, tell me why. If you could not do the following job, tell me why. For 6 out of 8 hours, you're going to be sitting at a security desk watching a 24-inch monitor, and that has multiple monitors that you follow for different cameras, and then when something happens, you have to pick up the phone and call a supervisor. You will very rarely have to deal with the general public, and basically for 2 out of 8 hours, you will be standing and or walking around 100 yards to take an ID badge from hip level all the way up to the upper right-hand corner of a door frame, which would signify at 10 stops over 100 yards that you have reached the location as a security person, as a check-in point. Can you tell me why you couldn't do that job? Now, for those of you that are listening to this for the first time, you're like a lot of claimants. You're not prepared, you know what you're thinking and things like that. My guys, they know. Difficulty typing into the screen, interacting with the computers, lack of education, hard time staring at a screen for extended periods, can't sit for, without shifting and losing focus and concentration for more than 10 to 15 minutes. In security job, you got to be focused on this sucker. Walking 100 yards, I can't do that. A walker, wheelchair, cane, crutches, cane, whatever. How's that going to work for security purposes? Can't lift hand above shoulders, right? That's one of the limitations. So, if you got to do that 10 times over a 2-hour period and make 100 yards, well, that's not bad for the average person, but you're disabled. There's a lot of things there. We didn't even go into the whole, interacting with supervisors, taking criticism, blah, 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 blah. There's a lot of things to consider here that are really relevant, and this is meant to be more of an introduction video for you to understand the basics of vocational expert testimony. If you do have more questions, before you shoot them to me and say, I want to know what the story is with this particular situation, before you do that, do me a favor, watch more videos on vocational experts and how that works for that part of the hearing. I've got other videos that take it from a slightly different viewpoint that would really help you understand why this stuff is all relevant. But if you do have questions after that, it's fine, shoot it to me. Keep in mind, I get back to my clients right away. If you're not my client, it might 2 days, 3 days, it might be a week. But that's purely because I'm constantly working. Now, with that said, I work on Friday, Saturday, and Sunday. Now, with that said, I'm about to have a house. That's my house for the first time, renting for 17 years. Because I'm white and male, which means my student loans were $425,000, which is incredibly bad. But I also grew up in a time when white males were treated horrifically by essentially white male politicians. And the Supreme Court even had to come in and limit how they handled student loans and academia when it came to admissions and stuff like that, because it just got rampantly out of control for how unfair they treated some individuals over others, which is why I work Friday, Saturday, and Sunday and do not have a normal life like all of you people used to before you had your disabling conditions. So, with that said, I will try to get back to you as quickly as possible. If you want the most up-to-date information, a free consultation, or a custom video made about a particular topic you like, that's fine. Put it in the remarks section for the custom video. I had a list and it got screwed up with the hard drive I have, but I'm going to be making a blog platform on the website that you can click into and then basically just put it there. That would be the easiest for me, because I could just literally go through those one day and just boom, 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 hit them, Either way, we've got about 50, 60 video ideas right here that I'm going to be doing. And that's the video. I'll catch you a little bit later. Have a wonderful day, and we'll go from there. Thanks so much. Bye-bye.